Jack's donation page, he has an audio clip of that statement. It is like 4 words kind of out of context. The actual statement was something to the effect of using your religious belief as a justification to discriminate is reprehensible, something like that. And so it's been twisted into it. He said that religion was reprehensible and that there's this animus. That's not there. It does remind me, though, of the O'Brien case, where in O'Brien, one of the questions that they looked at with the draft card burning case was whether or not the statute was passed with a specific purpose to stop hippies from burning their draft cards, or if there were other reasons to require that draft cards be kept intact. And the Supreme Court said, well, Strom Thurmond gave 1 floor speech, 3 representatives, then it passed by 393 votes. I have no idea whether all those other votes were for the same reasons as were said on the House floor. It's impossible to pry behind legislation and find this animus that's in there, and then say this statute's invalid because of the animus, but if you pass it again for better reasons, then it will be valid. That's just not something the courts can do.
But they brought up the city council members who had, I guess, said something disrespectful, and they asked the representative for the state whether or not they would kind of disavow what the city council member said. So I kind of picked up on that as, is that a potential for kind of the legislature showing their hand as far as being adverse to?
No, it was the Civil Rights Commission. It was one of the members of the Civil Rights Commission. I don't know if he spoke for the other commissioners, but look, the legislature actually carved out, we want to make some accommodation for religious people. Bob asked, well, why not religious belief as opposed to just religious establishments? Well, because they knew about Newman versus Piggy Park, and that people would say, my religion requires me to discriminate, and my retail establishment's actually a religious undertaking. There's also the question of whose religion. Jack Phillips owned his own business and he worked there, so he's the employee, the shareholders, and the director. But if we're looking at a bigger restaurant, is it the shareholders? Is it the management? Is it the board of directors? Is it the employees? Whose religious beliefs matter? I don't think that the Supreme Court's going to overrule Piggy Park and say, on second thought, if you really, really mean it and with religious fervor, you're allowed to discriminate against members of protected classes. I don't think that they're going to go there, and it wouldn't be workable for them to craft a test that worked.
Not really. Do you have anything to add to that one?
No. I don't need that.
I have a couple questions and a couple points that I would like to run by you two. Earlier, a statement was made that that the cake that was already in the channel of commerce is not channel, but already in commerce was not the same level of expression as a cake was when asked to be made. And a statement was made that there's a different labor between a cake made for commerce and a cake that was specialty. My question is, how do you quantify the labor? Because the cake that was made for commerce could have been the same exact amount of time that the cake made for the expression. So using the labor argument where he spent his time, he sat there, he worked hard and labored over the cake, and people see that and they're going to say, oh, this is his speech. But the cake that you buy from the shelf that was already labored over and taken time, isn't that the same speech?
Well, if you're telling me I have to come up with a rule that's going to cover every circumstance that you can conceive of, I'm going to confess that I will not be able to come up with such a rule. The rule I came up with said that standard off-the-shelf products should be subject to public accommodations law. You cannot discriminate in providing those products. But custom-designed products, defined as anything that either has expressive artistry associated with it or that requires unique time and effort. Now, the word unique is critical. That means time and effort over and above what is required to make a standard cake. So if somebody is simply taking one cake off the assembly line, that's not unique time and effort. But if the baker is being asked to devote unique time and effort to the process, to the making, to the selling of the cake, that should entitle him to refrain from expressing a message with which he does not agree. Are there going to be some murkiness applying that rule? Of course there is. Courts are involved in this sort of stuff all the time, but we do need a rule that distinguishes some cases versus other cases. Otherwise, we are left with the Colorado Public Accommodations Law, which right now has no rule that says that the baker can't be compelled to say, I love gay marriage, even though in fact he hates gay marriage. He condemns gay marriage.
But wasn't on the cake, there was not, the cake was just gonna be a wedding cake. There was not gonna be, I love gay marriage on
Well,
it.
we don't know what there was gonna be because they didn't discuss it. What
But it's
we
a-
do know is that the rule would cover those instances where unique time and effort would be required. And it would not cover those instances where unique time and effort would not be required. If there is a different rule, I am wide open to hearing it. My point is, there must be a limiting principle. The Colorado law goes too far. It violates free speech, and we have to find a way of reining in that law.
That's all. We're on time for questions. Now we have to go to closing remarks.
I mean, some people have 4 questions. That was,
We're gonna have more debates.
I'll happily hang out afterwards and answer anybody's question. Closing remarks. We've already litigated this 60 years ago. The question of whether or not my status as a business owner entitles me to decide who I want to serve and who I don't in a public accommodation, that was answered by the 1964 Civil Rights Act. It was fought hard in Congress. Strom Thurmond famously tried to filibuster it. But we fought that, and we hammered out the 1964 Civil Rights Act. It's been the law for 60 years, and I think I'm in a room full of mostly people who have never been told in their entire life, we don't serve your kind here. Because in 1964, it didn't instantaneously happen. There were riots, people were killed. It was a hard-fought battle, and is eating at a lunch counter or bowling at a bowling alley something worth dying for? No, but the dignity of not being told people like you aren't allowed in here, that was worth fighting and dying for to people. So we have litigated that question. We've litigated the question of whether or not your religious beliefs entitle you to disobey civil rights laws, or for that matter, any other laws, just because you've decided to adopt a religion that says complying with that law is against it. You are expected as a cost of living in a civilized society to comply with laws even if your religion doesn't require you to do that, as long as it's a law that's neutral, it's not targeted at your religious activity, and it's of general application. We've litigated that. We've litigated the question of whether the right of free speech entitles you to deny service to somebody as a member of a protected class in your public accommodation. There is nothing new in the Masterpiece Cake Shop. These arguments that are being floated around that sound great to people who think pro wrestling is real. Well, what about if a Jewish baker had to bake a cake for Nazis? Oh yeah, that's a good point. That's not a good point. Nazis are not a protected class. We're relitigating something that we fixed a long time ago. I showed you pictures of what it looked like before we fixed that. And I'm not just talking about law, I'm talking about a lot of things. I can't believe that in 2018, we're still talking about whether or not somebody should be served at the Woolworth's lunch counter. I can't believe that we're still talking about whether vaccines are a good idea. There's a lot of things that we fixed a long time ago, and it's fire that we're playing with right now when we say, even though we fixed this, even though we fought this war, even though the war has been won and lost on both sides, we've arrived at a solution, we've all agreed on it, and let's maybe roll it back to the way things were 60 years ago before we fixed it. It's a dangerous fire to be playing with. It's one we shouldn't be playing with. And my prediction is that the Supreme Court is going to hold that baking a cake is not expressive conduct, that Piggy Park has already resolved the religion issue, and they're going to affirm the decision of the Colorado Court of Appeals with a very anticlimactic and short opinion.
Of course, we have not relitigated this. If we had, the case wouldn't be before the Supreme Court. There's no binding precedent that covers the Supreme Court. The Supreme Court can reverse any prior precedent if it wants to. And further, there's no binding precedent regarding compelled speech in any of it. And we did litigate, of course, whether or not religious preference entitles you to behave differently than the statute requires. We did that in the Hobby Lobby case. And the Supreme Court said, yes, it does allow you to act in a different manner than the statute requires. And you will not have to comply with the Affordable Care Act if you have a sincere religious belief. So many of these things have been litigated, and they've gone the other way. We are not relitigating the Civil Rights Acts either. I concur. Mr. Phillips cannot refuse to serve gay couples. He didn't refuse to serve gay couples. He refused to serve one particular act that a gay couple proposed to engage in, and that was a same-sex wedding, an act that he finds repugnant to his own religious beliefs. So we're no longer in this world of Jim Crow, where state-supported segregation exists. Our Constitution bars discrimination based on race, color, religion, gender, and after the Obergefell decision, it allows a right to say